William, hopefully your favorite videographer from Two Hats Publishing. I welcome you to another Two Hats special of community events. Let's look in and see what's really happening.
Hello, how are y'all doing today? So my name is Dominique Walker. I'm the Smart Justice Field Manager for the ACLU Texas Smart Justice campaign. Thank you all for coming to our first State of Smart Justice event. Directly to my left, we have Roderick McNeely, one of our advisory board members. Do you want to introduce yourself?
My name is Roderick McNeely. I am a formerly incarcerated person who I've been out of prison now for 9 years. I operate an alternative housing program for men coming out of prison. I am an active advisory board member for the ACLU in Dallas, and I am a graduate of the Anthony Graves Smart Justice Speakers Bureau of the ACLU of Texas. And currently we're in the process of getting 3 bills drafted to help formerly incarcerated when they get out.
And sitting next to Roderick, we have Ms. Chaz Rogers. Do you want to introduce yourself?
Yes, my name is Chaz Rogers. I'm the mother of Anthony Hudson, who was murdered here in Dallas County in 2011. I serve as an advisory board member looking for transparency and accountability with Dallas County.
And last but not least, the reason why we're all here to hear from District Attorney John Creuzot, and I have a bio. Do you want to say something before I jump into it?
No, go ahead.
No. So John Creuzot was born in New Orleans and spent his youth in Houston before coming to the Dallas area in the 1970s and graduating from University of North Texas in 1978 and SMU School of Law in 1982. He currently lives in East Dallas with his son Ethan Creuzot. He's a retired judge and an award-winning lawyer with more than 3 decades of experience in the criminal justice system, including more than 21 years as a felony district court judge. His background also includes 7 years of service as a Dallas County ADA and chief felony prosecutor, as well as a criminal defense lawyer while in private practice. He has a laundry list of awards, and I'm going to put them up here, as well as serving on several boards here in Dallas. And in addition to his trusted service on both sides of the bench, Creuzot has earned a national reputation for his innovative work on drug court, criminal justice reform, and evidence-based sentencing. He regularly appears in the news and on television as an expert on these and other criminal justice topics. He has lectured and taught courses at the National Drug Court Institute, the National Judicial College, and the National Center for State Courts. He has also presented at several national training conferences for the National Association of Drug Court Professionals and has taught drug court teams from across the country. Creuzot has lectured and directed seminars for the Texas Center for the Judiciary, the Texas Bar Association, and the National Association of Drug Court Professionals. After his retirement from the judiciary, Dallas County honored Creuzot by renaming its drug treatment facility the Judge John C. Creuzot Judicial Treatment Center in May of 2013. The center provides an intensive residential program as an alternative to incarceration for Dallas County probationers. The facility is coordinated with the Dallas Community Supervision and Corrections Department and the Dallas County Courts. The center works to ensure successful substance abuse treatment and reintegration into the community. It also offers education and skills training and job search assistance to probationers and education and counseling for family members. Can you all join me in welcoming John Creuzot? So now I'm going to kick it over to Chaz, who is going to take us through an overview of the Smart Justice work. For those of you who are not familiar with the Smart Justice campaign, it is the ACLU's attempt at helping to reduce mass incarceration by 50% and to combat racial disparities in the criminal justice system. Chaz.
Thank you, Dominique. The Smart Justice of Texas, we had a fantastic time in 2018. Here is the overview of the American Civil Liberties campaign work. The first primary election, we began the process with John Creuzot, Elizabeth Frizzell, and the no-show of Faith Johnson. Second, we canvassed the communities. We strengthened the communities with the commitments and the consist of men and women, boots on the ground, knocking on doors, and handing out flyers, talking to people about voting and the DA's race. Next, we print pieces. We provided print pamphlets on educating the voters, the DA, and the policies at hand. The advisory board, which is made up of the Smart Justice with real people with real issues. With the request of Dallas County on transparency and accountability, we meet regularly to educate the ACLU of their platforms and the candidates to strengthen Dallas. The workshops. We initiate numerous of workshops through community education, the community partners like Anthem and Tory, etc., a host of DA for a day, whereas we role-played through court cases such as 2 real cases, 2 fake cases of the failed criminal justice system. Most beneficial, we the advisory board members shared our stories as the evidence, as proof that the failed case of criminal justice system. The general election forum, which is the exciting of all, we invited both candidates to tell where they stood on the policies. As we know that Faith Johnson didn't show. She didn't show for the first one nor the last one. But we do have here with us now the elected chief of DA, John Crusoe. Now we are at the accountability phase to reflect on the answers from the questionnaire and the forms of commitments made during the election cycle. At this time, I will turn it over to Roderick McNeely.
Thank you, Chad. Before I get into this, District Attorney Crusoe, I would like to say congratulations on being the newly elected District Attorney for Dallas County.
Thank you. Appreciate it.
We also want to thank you for your commitment to the ACLU's events to make the public aware of your policies. We also want to thank you that you did have some good commitments that would benefit the community as well as the prosecutor's office in regards to immigration, how you will prioritize and prosecute drug-related offenses, probation guidelines, and last but not least, seeking the least severe acceptable punishment for all offenses. As time goes on, we will continue to stay engaged with you on these particular policies. But right now, I would like to ask you to give us more details on a few commitments that you made. The first one is, what are the steps you're going to take on hiring people with criminal records to work in the DA's office?
Well, number one, a person who has a criminal record is not automatically excluded from working in the district attorney's office. There may be for certain jobs, depending on what it is. For example, depending on what the criminal record is, we may not be able to hire someone as an attorney, because the federal law, as far as the criminal background databases, they would not be eligible, and it would actually impact the entire office. However, since I've taken office, we have hired 2 formerly incarcerated attorneys to work in the office. When I say formerly incarcerated, obviously not felony, because that would completely exclude them from being able to work in the office and would actually impact the whole office. But one has an extensive misdemeanor record and one has a much shorter misdemeanor record. Both have been incarcerated, one incarcerated many times. He has applied many times to the district attorney's office and was turned away, but I hired him. So he's on the way. Well, I say I hired him. Actually, we're waiting for a spot to open, sorry, for his skill level. So,
thank you for your diligence.
yes.
Number 2, what programs will you have to make sure your prosecutors do not have racial bias in how they prosecute cases?
The Texas District and Counties Attorney Association has just developed an implicit bias. When I say just, I mean recently, and probably presented it for the first time. There is an African-American district attorney in Brazos County, I think, Jarvis Parsons, very nice guy. He's one of the trainers for that. And as soon as that gets going and they get a little more experience with it, I think they've only done it once. But what I'm doing is looking at all of the trainings that we have, and not just implicit bias, but other things. Because what we need to do in the Dallas County District Attorney's Office is change the culture. That's one small aspect of changing the culture of the District Attorney's Office. So it'll be that and other things. In fact, some of them I'll probably do myself to make certain that I communicate the importance of culture change and looking at the criminal justice system from a different perspective to get better results.
Okay, again, I applaud you for that. Hands-on experience is definitely what's needed in the district attorney's office. Number 3, what programs will you have to make sure your prosecutors, okay, we just did that one, I'm sorry. What's your plan for having staff dedicated to working on existing treatment programs?
Well, our existing treatment programs are working pretty well. We have some programs that are not really programs, they're kind of dockets in the courts. And I don't know a whole lot about them. I have not yet met with the judges, district or county judges. I've offered, and that hasn't happened yet. I think bail bond reform has got everybody kind of on edge for some reason. So I am willing to work with the judges to improve their programs. We've had some programs that we've closed down because the city has changed its enforcement policies, but they're about to change them back, so we may open up some programs again. Our mental health programs, we're trying to expand them and make them better. We're trying to do everything we can to get the mentally ill out of the county jail and out of prison, and not send them to prison. And that's kind of a different program, but it's a program.
Yes.
And we're expanding the number of lawyers in the programs. What I found when I got there was we had a lot of programs, but they were scattered about. So this DA thought this was a good idea and stuck something over there. And this DA thought something else was a good idea and stuck it over there. And sometimes they were complementary and they should be working together. So what I've done is put all of that under one unit and given it a head. The person who heads it used to work with me in DeBert Court, and so she knows substance abuse, but she doesn't know mental illness. So I hired somebody from the public defender's office, excuse me, oh, goodness. But anyway, I hired somebody from the public defender's office who knows mental health. He's an expert in mental health and has worked with that population. And today, most of that unit and I said most, at least half of it and I, had a meeting because they have wanted to do certain things and handle cases a certain way, but nobody ever understood and they never got anywhere when they had the conversations with the person in my place. So they were quite surprised today when I said yes to this and yes to that, and of course to this and of course to that. And so we're in the process of expanding the number of supervisors and lawyers, but we're also in the process of expanding the number of individuals that we service. And we're also in the process of looking at dismissing cases for people who are mentally ill and get caught up in the system, and putting them directly into services. And some of the things we don't really need lawyers for, we were discussing today. It's my idea that we can hire paralegals, for example, who can actually monitor the cases and monitor the people's progress. The other thing a district attorney's office has never done is hired a caseworker or a social worker. And so obviously, if what I've got is lawyers, they're like me, they went to law school, right? They don't know anything about that, but they've been trying and they've been doing it and they've done a pretty good job. So what we're going to try to do is present to the Commissioner's Court ways that we can save money and yet bring people on and do a better job with this population and meet their needs and help them get the services they need without being caught up in the tangle of the criminal justice system. There are lots of services out here that can be accessed, and we want to get them to where they are. The chronically homeless have a constellation of problems that are not easily solved. So just saying, go here, and expecting them to go and everything's going to be okay is unrealistic. It's unrealistic.
Yeah, it's not working.
So what we do and what we want to do is have people who are trained to monitor them, but to monitor them to get their services and to succeed in their services and keep the judges out of it. We don't need to do that in order to access services. So we don't need those kinds of court programs to help those people. So those are some of the things that we're looking at doing.
Since you said that, you bring to mind one of the bills that one of the young ladies out of Harris County that works with the Anthony Gray Smart Justice System Speakers Bureau is getting drafted by State Representative Ron Reynolds is a trauma-informed training.
Yes.
For all the city and state and county workers. Would that be something that maybe we could talk about at a later date, or something you'd be interested in instituting into these programs? Because when you're dealing with the homeless and the mentally challenged, it's going to be some trauma that you're going to have to address.
There's lots of trauma to address. I mean, I know that as a judge with all the programs that I ran. So, yes, I'll be interested in it. I'm not familiar with that. I'm having to track a lot of bills right now, and we've even sent some down that we're sponsoring and trying to find some sponsors for some criminal justice reform issues. But the person in my office who handles legislation, her name is Paige Williams.
Mm-hmm.
So if you will call her, you can call her at the main number,
Get that number, take that number.
214-653-3600. I don't know her direct now, sorry.
Paige Williams.
Yeah, Paige Williams.
Thank you.
And if you'll get with her, she can get me a copy of the bill. I don't think that's something that she and I have talked about. We talked about a lot of bills, but I don't remember that that's one of them.
Thank you very
Okay.
much. The last question is, what about having someone dedicated to transparency for the families of incarcerated individuals and speaking to them in a language that they can understand? Because many times when we're dealing with the court system and lawyers, they use this jargon that regular people don't understand, but helping them to understand exactly the process and what's going on legally.
Well, I've had a lot of phone calls myself, and I've answered them and talked to people, especially right after the election when everybody knew that, one administration was going out and another was coming in. I made it a point to return each and every one of those phone calls, even though I was trying to transition and trying to close out cases and what have you. But we do that. We have to be careful about it because people can be very sensitive. We don't know what their perspective on us is going into it, and so we have to be careful. But that is certainly something that if we don't do, we need to do more of. And I think that there is a different aura in the district attorney's office since January 1. I say that, I hear it from the staff, but I also hear it. I don't think I've missed out on any interview of newly hired lawyers who wanted to have a job. And many of them have told me that, and I know it's true because I can see the form that they filled out is different from the previous form, that the reason they're applying to the district attorney's office is because I got elected. And some of them have been, they're not like newly out of law school, so you don't know if they're telling the truth. They've been practicing 2 or 3 years, some of them. And one of them the other day, I asked him, so are you telling me if Faith Johnson had won, you would not have applied? And he said, no, I could have applied here a long time ago. But this is what I want to do. This is the vision. This is the direction. And so We have people who are more open to doing things like what you're talking about, talking to families. And it's the same thing I did as a judge. I mean, you can't communicate if you don't talk.
We have to be able to-
And nobody's an enemy. The family of, as I always said as a judge, when you send somebody to the penitentiary, you send their family too.
That's right.
Okay, and people don't realize that. And I've told the staff that. When you send somebody to the penitentiary, you send their family. And so we're not at odds. It may be inconvenient in a sense. I don't want to say the word inconvenient. It may be odd. You don't know where you are and you don't know how people are going to respond to you, but that doesn't mean that we shouldn't try.
Amen. Thank you again. When Faith Johnson was in office, she had 3 community advisory boards, and according to your website, you have 4. The community advisory boards, Faith Community Advisory Board, you have the LGBT Task Force, and the Youth Advisory Council. My question is, how are you going to find people from the community to work on your community advisory boards? This is a 2-part question. And what do you plan on using them for?
Those are 2 good questions. First of all, I haven't changed anything that she did, so I don't know why 3 versus 4. The other thing is I have actually not hired somebody to take that position. The person who had it said, and at the last minute quit. And when you quit like that, it's the way the county works is you just can't put somebody into place. They have to go through a process. Mm-hmm. And with all the other things I had to be, and I don't mean to diminish that position, but that was not the most important position that I had to fill. And so this week we actually interviewed individuals for that and are in the process of making a decision, and we'll put somebody in that position who already has community experience. So it won't be a new job to that person or a new experience. How do I plan to go about doing it? I'm going to task it to that person. I'm going to task it to my communications director, who has some experience with that, and we're people that I know who are active in the community, or anybody who wants to join up. We're going to put it on our Facebook page and put it on our site, invite people to do it, and we'll get it going. But right now it's dormant, to be honest with you. I'm going to make that up because, like I said, the person told me she was going to stay, and then she quit. And so I've just this week interviewed people for that position.
Okay, the Dallas Police Department, they're investigating. How do you the committee that they have, the oversight committee, and the Citizens Review Board that they have? I noticed that all of the people from the community that are on that board are either ex-law enforcement or ex-judges or attorneys. And my question is, how can you get the best results by just having ex-law enforcement, ex-attorneys, when they don't have the lived experience as an individual that actually is working in the community and has the first-hand experience? Is that a plan of yours to keep that policy, or are you going to do something different?
No, I don't have anything to do with that plan.
Okay.
Stick me in there.
No, it's not with the police, but I mean, are you going to follow that same pattern with your advisory boards?
No.
Okay.
I'm not going to exclude the police, but I don't see any particular reason where they have to be on. And I meet with the police chiefs on a regular basis, and they have my email and phone number. We communicate on my new policies and whether they agree or not or what have you. But as far as the Citizens Police Review Board, which is not within the purview of the district attorney, I think that it ought to be inclusive, and I think that it should reflect a number of professions, and I think also every geographic area. I don't think there ought to be any exclusions to it necessarily. You know, I mean, somebody who was up in Sherman ought not be on it, okay? I mean, but, you know, within reason.
Yes, sir.
I think there ought to be people from the Dallas, the city of Dallas community who I would call stakeholders, who have an interest in the issue and interest in doing a good job as a Citizens Police Review Board member.
Okay. And the last thing is, I see that you committed to dismissing all pending cases of less than 4 ounces of marijuana if it's the first offense, and also to not prosecute such cases. Can you expound on that further for me?
Yeah, it's a little more than that, actually. So we decided on a date certain, which was very recently, that any pending marijuana cases of less than 4 ounces would be dismissed. We said we were going to dismiss your first case. If that was actually your 5th case, we counted it as your first case for our purposes. So we dismissed that case. Okay? So some little smart aleck lawyer hit me up in the hall today on something I hadn't thought of. He said, "My client got 2 cases pending. What are we going to do?" I didn't even thought about that. So we went upstairs and discussed it and decided to dismiss those also. So the question is, what about the 2nd, 3rd, 4th, 5th, and 6th, or whatever? Well, hopefully there won't be a 2nd, and if so, hopefully there won't be a 3rd, and if so, hopefully not. So what we're going to do is, and things are subject to change, because we may see that what we're doing is not working, but I think it will. What we're going to do is never handle a misdemeanor marijuana case as a criminal case. They will always be eligible for what's called conditional dismissal, which is a contract between the person and the district attorney's office. The question is, what do they have to do to fulfill their ends of the contract? So typically there's stuff like community service that will not be included, because community service has no relationship to whether or not somebody's going to smoke marijuana or do anything. So that's out, okay? But it will be potentially an assessment of some sort, or some cognitive behavioral therapy program that addresses the use of marijuana. What we don't want, okay, is people getting arrested over and over and over. If you are a parent, let's be honest, lots of us are, even though we don't think that marijuana, maybe some of us think it shouldn't be illegal or whatever your thoughts are. You don't want your kid to smoke marijuana, let's be honest, right? You don't want your kid to drink and get drunk, and you don't want that. But the reality of it is, it's not the boogeyman that the system has portrayed it to be either, okay? It's not a gateway drug. Gateway drug is over at the liquor store, right? And it's not going to cause you to go out and kill somebody. That's a myth and a rumor. So what we're going to do is have them attend some type of program that will address the thinking and the issues, and maybe they'll do better. Maybe they're better if stop riding around getting high, okay, and getting arrested. Maybe that's their better, I don't know. But we'll do things to help them, and we don't have any plans to treat that as a criminal justice issue. Now, what else have we done that we didn't say to the ACLU or anyone else? So we have THC cases, gummy bears and all that stuff, right? It's not marijuana, it's the active ingredient that's put in something, usually bought in Colorado and brought to Texas, okay? We're not going to prosecute the first ones of those either. Those are felonies, by the way. And that's where we start getting into what's going to affect you for the rest of your life. So we're going to not prosecute those on the first ones, and we're going to always treat those also as a public health issue, not a criminal justice issue. Okay? What else are we going to do? So conditional dismissals. Every administration in the past has made you wait X numbers of years for the statute of limitations to run to get an expunction, get your case expunged. We're going to do away with that. You finish the conditional dismissal, you can file your expunction motion, and we'll process it and let it go through. Why? If it's hanging there and you've done your conditional dismissal, it may keep you from getting a JOB, right? It may do any number of things that are not positive for you. So what we're trying to do is to bring common sense to the criminal justice system in Dallas County. And we're trying not to allow the criminal justice system, though you may have violated a law, that doesn't mean we have to tear your life down. Okay? So what we're trying to do is look at these things that make sense, where you can go on with your life, you haven't harmed anyone, you haven't harmed anything, and if we can address the problem in a responsible way, then that's what we're going to do, and change the face of criminal justice in Dallas County.
Mr. Cruzo, I would like to thank you for your commitment to help reduce mass incarceration, not only in Dallas County, but in the state of Texas. And at this time, I would like to turn it over to Ms. Walker for the final Q&A session.
We got a lot of work to do together. We're good. So I think we lost our... No. So I think we lost our feed, but we can kind of talk through these last couple of questions. So
Okay.
Recently, your office was granted a $625,000 grant for 2 years to expand the conviction integrity unit. Can you walk us through some of the plans for that funding?
So conviction integrity deals, excuse me, with cases where people claim that they may be innocent, or it may be, well, usually they're innocent, but it also could be that the trial was just held in such a way that they just didn't get a fair trial for any number of reasons. So we have one permanent person in there, well, two, I'm sorry, permanent, and we had a third, and we put her back in a trial court because that's where she's better suited. And we are in the process of hiring someone who is an appellate lawyer. So conviction integrity is something that's different from being a trial lawyer. When you're a trial lawyer, you get a case and it goes to trial, or you plead it out, and it's usually in a short period of time. When you're in conviction integrity, you don't go to trial. You read, you write, you investigate. You look through documents. The documents may be 25 years old. You may be trying to find the source of a fingerprint from something that happened 30 years ago. There are any number of things. It may be a photo lineup that you're trying to find out whether it was a legitimate identification or not. That's a different skill set. And so we have recently, we're onboarding someone who is more suited to that type of work. As I have gone through these interviews with new hires, excuse me, I have tried to tag the ones in my mind, and by talking to them, that look like they could fit those qualifications for this grant position. And I think we might have found one who has done some trials, so she understands a trial. She's done some appeals, so she knows how to write. And I asked her, would she be interested in that 2-year job? We need a 2-year person. I don't need you there for 2 months. I need you there for 2 years, because those are long-term cases. And maybe she will, maybe she won't. But what I'm trying to do is actively solicit people with the right skills for that job. The problem is, and the problem in the DA's office is, they just sometimes stick people in places, okay? And you're not interested in it, you're not skilled for it, etc. We have a lot of those problems in our mental health programs. We have a lot of those problems in our substance abuse programs, okay? And it causes a problem. And it causes people to be in jail who ought not be in jail, people to go to prison who ought not go to prison. And so I'm trying to be very careful about that. We're also trying to increase our diversity. We're trying to increase our Spanish-speaking staff. In fact, I had them to pull this because I've interviewed, you don't hire everybody you interview, and we've interviewed so many people, but since I've taken office, we've hired 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 African American lawyers. 1, 2 of those are in upper administration. One is the chief of a court. And we've hired this is actually the two Spanish-speaking, one is conversant in Spanish. Our investigators, we've hired 4 African-American males, 1 Hispanic male, 1 white female, and 4 white males. So, and that's what we're doing. And one of the African-American male investigators, I don't know if he's one of the 4 or not, but he will be going into the conviction integrity unit. And so what we're trying to do is to be diverse, but also be skilled in what it is, where we're putting you, and what we're asking you to do. If you're not skilled, but you have an interest, then we'll send you to the training. And also, because of my background in mental health and substance abuse, I'm trying to help the staff think through what the policies are and what we're doing and why we're doing it, what we're trying to accomplish. If you go this way, what happens? If you go that way, what happens? What are, which one accomplishes our goals? If one doesn't, then why are we advocating going that way? And so, same thing with the conviction integrity unit. And I don't know if you know, but we recently had a case where the Court of Criminal Appeals actually declared someone, which is a victory, declared someone actually innocent. They don't do that very often.
Okay, so coming up on advocacy. So you've been a pretty big proponent of bail reform in Dallas over the course of the election cycle.
Yes.
So can you take us through, just have a couple of questions. So with the lawsuit, some of the things that you have said that you will help with is advocating for your prosecutors to request PR bonds. But when it comes to impacting mass incarceration, we know that we have to think beyond that. When it comes to felony arrestees, with this process change, can something that your office does, can one of those things be requesting that the prosecutors actually go that step further to actually request court settings?
To actually request what?
Court settings for the felony arrestees.
I'm a little lost there. What do you mean?
So with the current process, the misdemeanor arrestees are getting their adversarial bail hearings happen, but can your prosecutors actually be requesting court settings for felony arrestees?
Well, we are, and actually, that's a bigger question, and you know what you're doing, don't you?
We can talk about it later, but I just want to see if we can get kind of a dialogue going around.
Well, we might as well get into it now.
Yeah.
Amen.
So I know since I'm waiting until later.
Let's go.
So before I got there, and since I've been there, I have been a proponent of a system where a person is brought in from arrest, and within 12 hours, they will have a public defender appointed, and a member of my staff will be there, and we will run a criminal history, or a criminal history will be run. We will do a risk assessment, and the police report, at least a probable cause affidavit, will be there, and the bond will be set, whatever it is. We are, of course, not accepting marijuana cases. There's some other parts of that too I can go into later. But anyway, so the system was not built to do that. Physically, was not built to do that. So the county has spent $1 million trying to make the space amenable to do that. The only problem is the judges don't agree to do that. So instead of doing it within 12 hours, it's happening 24, maybe 48 hours later. Instead of having one system of doing it, the county judges have a system, and many of them have their own system of doing it, and then the district judges have some other system of doing it, and it's basically the person stays in jail, the magistrate, without a lawyer for the defendant or the state there, will look at the risk assessment, and there's some issues around the risk assessment, but that's not what you asked me. We can go into that later. But we'll look at the risk assessment, and I guess look at the probable cause affidavit, and make a determination of bond. If the person doesn't like that, the district judges have come up with a solution that the person can call the court coordinator and request to be brought up to court. I'm not exactly sure how you're going to do that down in the jail. That's what was suggested. or file, more appropriately, what's called a writ of habeas corpus, which is a document that will cause you to be brought up, and then you have your hearing. The problem with that is we don't always know when and where the hearings are. I have shown up to some hearings. I've tried to go to one myself, just so I could see how it worked. And the judge wasn't there, the defendant wasn't there, the lawyer wasn't there, we were there. So that was that. The judges have told me that some days the lawyers that they, rather than use the public defenders, they've appointed lawyers and they didn't show up. And the defendants did from downstairs. The judges have told me that some days the lawyers were there and the defendants weren't there. They weren't brought up. So, you know, are people getting some type of a hearing? Yes. Are they getting it with a lawyer appointed and a district attorney there and the information made available to the actual judge? Yes. Is it consistent across the board? No. Does it have to be consistent across the board? Not necessarily. It would work better if it was consistent, I think. I mean, I always thought that as a judge, that we should all try to do things the same way. So bail bond reform is happening in Dallas County. However, we have not seen a reduction in the number of people in the jail. So that brings us back to the risk instrument. So there are different risk assessment tools out on the market, so to speak, on trying to determine a person's risk to show up. I have had a lot of confusion as to which risk assessment tool we're using, because I don't know that the judges, between the county judges and the district judges, have ever really spoken to make a decision. I don't know. And so we were, I thought, using one that took into consideration your risk to show up to court, your risk to commit a new offense, and your risk to commit a violent offense, and would come up with a number to guide. The judge doesn't have to follow that, but it would be more information. Now I understand and I've seen that we're using one that doesn't have any risk to commit a new crime and doesn't have any risk to commit a violent offense. And I'll give you an example of that. So it scores from 0 to 9. There was somebody in jail the other day who is suspected of being a serial rapist. And this risk assessment put him at a PR bond. Now, as the district attorney of Dallas County, okay, we're talking about a lot of things. We're talking about mental health and drugs and then mass incarceration. One thing we're not talking about is a PR bond for somebody who's suspected of being a serial rapist. Okay? So that begs the question to me and to you. Is that the appropriate risk assessment tool to be used under these circumstances? Doesn't it? Sounds like a reasonable question, doesn't it?
Yeah, it does.
It is a reasonable. Calm down. We are not, I'm going to go ahead and say it. We, the stakeholders, are not communicating. Okay? I have not talked to any judge or group of judges about this bond issue. It's not for lack of effort. We're not communicating. You cannot have a system that is supposed to bring stakeholders together and develop policy. It won't be perfect, right? No policy is perfect. But you can't expect to develop fairly consistent, good public policy when you don't communicate. And we are not, NOT, communicating. And we need to stop it. And we need to start communicating, because this is too important. If we're doing this, making those, coming up with those kinds of outcomes, and the jail population hadn't gone down, and we're doing it inconsistently throughout one courthouse, that begs the question, are we communicating? And the answer is we're not, and we need to, and we ought to. And so I don't know what to say, except I'm ready to communicate.
Is there something that the community can help you with that communication? Moving that along?
I have offered, and, you know, show up to the meetings. I don't, you know, the county posts the meetings. I've been to 2 of the meetings. I think there was a court hearing at Judge Godby's court. I didn't go, but it was last week or so. And I think he had some things to say about it, but I wasn't there, so I don't know.
So I have one last question regarding bail reform. So there's been some murmurings across the country about non-money bail schedules and with conditions of release. Now, that's not something that you have the power to implement here in Dallas County, but can you give me your general thoughts about non-money bail schedules?
When you mean non-money, do you mean the person, does a person not have to post any money to get out of jail, or there are people who are not given a bond and they have to stay
So
in jail?
instead of a money bail schedule, a bail schedule that has conditions of release and money's not involved?
I mean, we have done some version of that, not to the extent that we should or maybe could. I think we're trying to move to that. There's a bill in the legislature that has some facets of that to it. So, you know, this whole thing, I mean, we intuitively say no one should be in jail because they don't have the money who will show up to court, right? That's what we know intuitively. What we don't know is how to measure that, okay? And the reason we don't know is because this is a new field, and there are lots of instruments going around, and the instruments need to be normed and validated on the population. That you're Dallas versus Seattle, 2 different populations. You use the same instrument, but you may need to ask different questions, okay, because of 2 different populations. And so we're in the process of learning more and more and more every day about that. And so that's why we're going to have these hiccups about it, and we can argue back and forth, but look what's happened. We're doing it, and it's, you know, kind of working, but the jail population hasn't really gone down.
Right.
So that begs the question, how well is it working if the jail population hadn't gone down?
True.
And so that's why I'm doing things like dismissing cases, even if you're in jail. We're trying to get the mentally ill out of the jail and get them into services and things like that. I can't wait around on that to do it. I got to take my own measures sometimes to get things done.
All right, so now that the easy part's over, we're going to open it up to some Q&A from the audience. Does anybody from the audience have a question for?
I know you do. I jumped out of your seat there.
So our advisory board member, Lanisha Jordan, is going to help run the mic.
Okay, I'm Ron Unger, I live in Dallas.
Hello.
I have two questions.
You only get to ask a half a question. You don't get to ask 2.
Well, okay, so
Okay, go
you
ahead.
talked about a lot of the programs that you're putting in place to help, you know, keep people out of jail and direct people
Yes.
with drug problems or mental illness problems. Is there a method or process that you have to track the effectiveness of those? Because it's one thing to have the programs, which is...
No, I just got there. I just been there since January 1.
No, I just mean...
But to track it, and from now on,
Yeah, I mean, is there a specific...
Yeah.
The thing is, it's great to have a program, but if you don't have a way to track it, you can't measure the...
We're working on that.
Okay, I think that's an important thing.
yeah, we're working on tracking. One of the things we're working on tracking right now is the money saved, because, you know, I got to deal with the commissioner's court. I just can't create a position, right, and fund it myself. So what we're trying to do on some of these things is track the number of people who are no longer in jail or who are let out, and on average, they would have been in this much. And so we can come up with a ballpark figure. And so we think that'll help us fund some of the positions. The other thing is there, and I didn't mention this, there's some grant money kind of running around that we have access to, but with the shutdown, it kind of got slowed down. So those are some things that will help on the mentally ill. The other thing is the Texas legislature is considering bills that will put money into pretrial diversion for state jail felonies, which is our lowest category of felonies, which will make me very, very, very happy, because we have messed that up so much, because what we do is create recidivism on state jail felonies, and I think a lot of lawyers don't realize what they're doing and the public doesn't realize it's going on. So yes, we're trying to track some of what we're going to do. We don't have answers to it yet because we're just trying to get it in place. And then we're looking forward to these other things that we think will help us get better outcomes and we can track them too.
Okay.
And by the way, that money won't come without a tracking component to it.
And I was saying that in fact the money is really good, that can help justify it, but also tracking the effectiveness of how many people were diverted so that if the program went in place, these people would get jailed. Instead, if you're tracking the effectiveness of how many people are benefited from these programs, that would be good just to know that the community.
That's a cost-benefit analysis, and so we did one on divert court, but we did a very limited cost-benefit analysis. We only did criminal justice savings. We didn't expand it out to the families and other things. The ratio would have been much higher had we done that.
Okay. And the second question I have is, Larry Krasner, when he was elected as DA of Philly, created a memo, and the memo was, kind of famous. I'm sure you're familiar with it.
I am.
But the first statement on the memo is the point of what he wants to do is to end mass incarceration. That's how he starts it. And then he talks about the various things that he wants to do. And one of the things that he had every ADA or prosecutor do is justify the cost, which I think you're kind of talking about, justify the cost of incarcerating somebody, so that if you're going to try to put somebody in jail, you need to justify, here's how much it's going to cost, so that you can do a cost-benefit analysis of putting somebody in jail for $60,000 a year, or doing something alternative that would help society, not ruin their families' lives. But, so basically take it out of that, that money's now available if you're not spending it on jails to do other programs that could actually be helpful. That's one thing he had in there. And another thing that he put in there was, where's my note here? That I thought was really good, is that when you ask for a charge that you for the plea bargaining thing everybody's doing, you ask for the lowest on the recommended charge list, the lowest of not the highest, because typically it's been the highest. I don't know how we do it here, but we do several things. But the thing is, he wrote the memo, and he basically lost a bunch of DAs that weren't going to do it. And I don't know if you've written down what you expect your ADAs to do, so that they understand this is what we're doing. If you can't do this, then you're going to have to go. And he lost a bunch of people, but he also made a huge change in the office there. So anyway, I don't know if you're planning on doing it, if you've done that. It sounds like you've done a lot of that verbally, but I don't know how official some of the things that you're talking about are to your people that work for you.
Well, first of all, I've always said if they don't share my vision or won't do it, then they need to go. And if they don't go, I'll take care of that. So that's number one. So I'm not really worried about that because I have a bunch of 25 and 30 and 35 and 40-year-olds, okay? And they live in this world. And I'm more concerned about, others outside that impact the DA's office, to be quite honest, than I am, generally speaking, about my staff. First of all, Mr. Krasner said all those things were presumptive, not necessarily to happen. And Mr. Krasner will admit that not all of his staff is on board. Mr. Krasner will admit that he doesn't quite yet know the impact of all those things and how it comes out, but his intentions are great. He's gotten a lot of national press and attention, and I applaud him for that, but I don't see that a lot of what I'm doing is any different. He's been in office longer, and he's had a larger opportunity to get a grasp on things than I have. So I will tell you this, and I'm sure it was the same for him. I have discussed this. It's kind of funny, actually, with some other people who are like me. But when you think about it, when you're an assistant DA, you have a caseload. So back in the days, I had 350 cases, but they were my cases, and I worked them. Then I went into private practice, and I was by myself. And I was a judge for 22 years, and I had 2 employees. And I was in private practice for 6 years, and I had no employees, just myself and my laptop, right? And I did a digital practice, and I had an office. And now I got a $45 million budget and 400 and something people who I don't even know. And so what happens is it's quite overwhelming. and just trying to get a grasp on what the hell is going on, okay? And so what is happening is the staff is coming to me with ideas. There are some things that I've put out to the police agencies that, quite frankly, they were not my ideas, they were the staff's ideas. And a lot of the things that, as we work through these, I can't think of every possibility, but they can bring things, or they can tell me things, or have you thought about this? And, well, no, I haven't. You know, have you thought about that? No, I haven't. And so what we're doing is working in a collaborative fashion. In fact, not this Friday, but a week from this Friday, and I'm going to do this on a regular basis, is bring all of the upper staff together and sit down and have them to tell me where their problems are and what I need to do, if I can, to solve their problems. And do you need more staff? Do you need less staff? Are people, the wrong people in your section, or what have you? So it's a learning process where I can learn with them. So what I get out of that is that they feel comfortable, right? They feel listened to, they feel valued, and they are. And they tell me that the atmosphere is so much different today than it was, you know, in December. That they feel that things are moving in a progressive direction. It's more of their generational kind of thinking and thought. You know, we still got some work to do on that death penalty thing, but you know, we're going to work on the juvenile. Mr. Krasner just got around the juvenile. We're going to get to it too. I really don't even know what my civil section does, so I got to get that figured out. Why does that matter? Asset forfeiture.
Why would that matter?
No, it matters because of asset forfeiture. The civil section does asset forfeiture, right? And so that's one of those things that, you know, so what's going on? I'm going to change the subject a little bit. What's going on with asset forfeiture? Well, I'm not doing anything because the legislature's so busy doing all these things. I'm going to wait till the session, so we may not even have asset forfeiture if some of these bills go through. So really right now, on some things, I'm just taking a wait and see attitude. But we've also been pretty aggressive on some things. One of the things that we've submitted, and we've gotten acceptance from one or two legislators, one of the problems we have in the criminal justice system, and you don't think about this is not something the average person thinks about. You know that the prosecutors have to turn over evidence, right? And you know that they not just turn over evidence, but even more so turn over evidence that shows that maybe you're not guilty or you shouldn't be punished or whatever. Well, the problem is that sometimes the police don't give us the evidence. But guess who gets to lose his law license? Me. Guess what happens to them? Nothing.
We can fix that.
We can fix that. So we have proposed a bill that doesn't have any sanctions to it, but it's a bill that gives them a duty and a responsibility to give us the information. And I'll give you an example. On December 3rd, I tried a case where there was a video that was taken in May of 2016 that I didn't know about until just a few days before trial. Why would they hold on to it? I got my own reasons, but it doesn't really matter. But it's those kinds of systemic things that you all, the average person in the public, doesn't think about, that I have to think about to try to make this system work better and try to get some legislation on so we can straighten this stuff out so we don't have the possibility of an unfair trial. So anyway, Krasner, he's got a lot of good ideas, and yeah, there are a lot of the same things, but you know, don't forget his are presumptive. We'll have some presumptive things on probation, and we're not finished. Okay, we've talked about a lot of things, but we haven't even gotten really started on what we're going to do.
Well, I mean, I think the ultimate measure is reduction in incarceration, right? Because the goal is to reduce mass incarceration.
Yes.
That's why, I mean, that's the main thing. I mean, there's reasons there's mass incarceration, and those have to be addressed. I know it's not easy, and I do appreciate the fact that you're trying to do that.
Well, so let me say this. These bills that are going through that deal with state jail felonies, those are the kinds of things that will reduce mass incarceration. Not prosecuting first-time marijuana offenses sounds good and is sexy and this, that, and the other, but I will be the first one to tell you that that has very little to do with ending mass incarceration. You know why? We all give them conditional dismissals and dismiss the case anyway. Okay? So that doesn't, it's sexy and you know, all that stuff, but if you want to get into reducing prison populations, you better start talking about drugs You better start talking about mental health. You better start talking about felony offenses. And you better start talking about keeping people from having the opportunity to go to prison. And sometimes you have to make hard choices. I'll give you an example. There's a provision in the law. It's section 12.44A of the Penal Code, which allows a person to plead guilty to a felony offense but be punished as a misdemeanor. Okay? You want to talk about mass incarceration? You go look at the numbers. Number one, it's the defendant's option. Are they choosing it? Yes. Are the lawyers signing them up to it? Yes. Is the judge going along with it? Yes. Is the elected district attorney and his or her assistants going along with it? Yes. What's my point? We're all complicit in mass incarceration. We are all complicit in mass incarceration. And what happens is these people get a felony conviction, and they usually get out the same day out of jail, and it's usually a drug case, and they usually have a drug problem, and it never gets addressed, and they go pick up another case. Well, by this time, they're not going to give you a 1244A. They're going to send you to where? To the state jail, and send you to prison. You pick up enough of those, you start going to the big prison. You pick up something else, you do something else, you commit a robbery. And so we are complicit, all of us. Okay? And that's why the culture of the Dallas County District Attorney's Office needs to change. Others may be, the judges are not. Judges are trying to do a better job, I know that. Defense bar, public defender's office, its director is here, she's great, she's phenomenal, doing a good job. But if we don't all stop doing what we're doing, nothing's going to change. And so that's what we need to do. Stop doing what we've been doing so we can change and get a better outcome.
So we've got about 12 more minutes. Does anybody else have questions?
Okay. I'm Mike Campbell. Actually just started working with the Technical Innovation Project to help with some of the building promotion documentation. Now, I was a little bit confused when you were talking about that. Is there currently one expected process? I know we're working on improving it, but is there currently one expected process if you get arrested and you're brought into jail? So I know you mentioned that you would like it open 12 hours for the district attorney, but we know that that's not always happening. So is there one expected process yet, right now? So we think that this was going to happen when we're trying to improve it.
Well, what we expected to happen was you would see the magistrate within 12 hours, and there would be you would have your lawyer there, and an assistant district attorney was there, and we'd have all these things done. That's not what's happening. You are seeing a magistrate. I don't know that it's happening within 12 hours, but close to it. You are seeing a magistrate, and then if you don't get out or you want to have another hearing, you have to file another document perhaps and get up to see the actual judge, and that can be sometimes 24 to 48 hours. So what we were trying to do was push all that. It didn't mean you would never ever see your judge. You could, but we were trying to get the representation, the communication. Maybe there's no case there, and we need to dismiss it. You don't need to go upstairs. But since nobody's down there, we don't get to have that discussion anymore. And so, it's just not what we expected. It's different. Once again, is it working? Yes. Is it working the same way that other one would work? No. Does it make it bad? No. But it's just not the same. The main problem is we are not communicating. And we need to communicate.
When you say we, you mean?
All of us. The judges, the DA, the public defender, we need better communication.
Does anybody else have questions?
I don't need the mic. My voice carry enough for a little girl. Oh, yes, you are not really.
Okay.
I just have a question.
Yes,
My
ma'am.
question is, what are we going to do about HIV criminalization when your DAs and prosecutors do not know what you mean. They are charging us with felony aggravating assault with our bodies, which if you are undetectable, you cannot transmit anything to anyone.
Well, the law requires that you know that you're transmitting before you can be charged with aggravated assault. So if it's something that you don't know about, we couldn't prove the case.
Thank you.
You're welcome.
Does anybody else have questions?
Thank you. I am Shane Tiffany out of Cedar Hill. Comment and a question. The comment is, I'm so thankful that you are our current community, and I know that you're going to help make history and make a difference in people's lives and their families' lives. And so my question is, I know that you just mentioned earlier that you have a few bills that you're looking to get sponsored. Could you tell us what some of those are interested in?
Yes, some of the bills come to me is, will you support this? For example, the bail reform bill, and my answer is yes. So it's not something that I did. The one to kind of, I don't want to say it's hold the police accountable, but put it that they have a responsibility and a duty to turn over evidence, that's mine. We drafted that. We are in partnership with the city in drafting a bill to put Class C, which is fine only, usually municipal or JP court family violence cases, on the general criminal database. So we know if somebody comes through with a misdemeanor or a felony that they've been handled with one before, and we can proceed as we should. It may be an enhancement, it may be the amount of bond, it may be protecting what we need to do to protect the victim or whatever, but knowledge allows us to do what we need to do. That's one of them. I was the first one to sponsor, and I can't give you all the details of them, I'm sorry, there's so many bills, but we are doing 3 things on conviction integrity to make it, to get around some court opinions. Number 1, we've had some cases where the state and defense agreed to relief that the person was innocent. The Court of Criminal Appeals said, not so fast. No, you don't. And so we're trying to sponsor a bill that would make that more likely to go through if it's agreed to. And there are a couple of other bills, I can't remember all the details, on conviction integrity, and would help people to be found that, well, make the process a little easier on the finding of actual innocence, but certainly to get another trial if they need it. We're doing that. God, I can't think of, there's so many. I mean, there are a lot of them that come to me that are really drafted by legislators, and they want some help, they want support, and I just, got a binder that thing. So I can't, those are the ones that stick out. Yeah.
We have time for one more question. 2 more.
Yes, Judge, I'm James Reed. I'm with a faith-based nonprofit organization called the ALCU Foundation.
Okay.
And we have a faith-based initiative program at the Hutchins unit where we have an 8% recidivism rate. Are you familiar with diligent participation?
With what?
It's called diligent participation.
Diligent participation?
Yeah.
You mean time credits on state jail?
Yes.
A little bit.
Okay. It seems to be very strange to know that this was supposed to be in place to help reduce recidivism.
I wasn't there to reduce recidivism. It was there to reduce population.
For population.
Right.
But there's no one is tracking that. And so I've never seen any results of how it has decreased population since it's been put into law. So
okay.
Can we in any way find out whether or not what it has done? Because there's no evidence at all to prove that it has done that.
Well, let me say this. So I'll say this. When it was first put in, it was very narrow, and it was discretionary upon the judge. My understanding now is that, I don't know, well, the method for getting it counted was onerous. The judge had to do this and send it back, and judges weren't doing it. okay? So I think that the process is easier now to get the credits. They're talking about expanding the credits in some bills that are coming up. But I would imagine that somebody has tracked that judges have, that people have been released because of it. I mean, it would have to be part of their release papers. Well, that doesn't mean they tracked it, so that's a different issue, isn't it? Whether they tracked it. I don't know the answer to your question. I would not doubt that somebody has tracked it, but I don't know whether they have or not. Diligent participation was, I think, in my opinion, primarily designed to reduce state jail population. So.
For those of us that don't know what that is, can you just elaborate?
Yes, if you do this, you get so much credit, you get a little bit here and a little bit there. And it's changed over the years, and since I was a judge, and the last time in 2012, they've changed it a lot. And because I wasn't a judge, and I didn't have to deal with that, so I didn't really keep up with it, but I know it has changed. The method, the process has changed and made it easier for the credits to be given to the individual. And I would imagine that the state or some public interest group in Austin has tracked it. I just can't imagine it hadn't been, but I don't know. Yeah.
One final question from the audience.
I think we got one right here.
Right here.
This might be tangentially related to the participation.
Oh, go ahead and ask it. It's okay.
So I'm ignorant. Are you over the municipal court?
No.
Dang.
I'm in I can't fix your tickets.
I had a horrible experience observing municipal court about a year ago.
So have I.
All these people fines on their tickets and for driving without a license, for being sent to loose stairs were off their fines.
Yeah. We're going to change that. So let me tell you what we're going to do. This driver while license suspended because of fees. So, what the system does is gives you another conviction, which adds more fees and resuspends your license. That's what the system does. All right? We're soon are going to stop that. And what we're going to do is when you get a driver while license suspended case, we're going to abate the case. And our goal is for you to get with DPS, Department of Public Safety. Their indigency program is rather onerous. Probably most people wouldn't be able to do it because it takes 3 tax returns and this, that, and the other, all of that. Yeah. So, but you can get on a payment plan. And so what our goal is for you to pay off your fees and get your license back, and then we'll dismiss your case. So instead of piling a problem on top of a problem, we'll help solve a problem and then get rid of another problem. And so that way we can have people with licenses who have IDs, who can get insurance, and who can drive safe and sound and don't have to be in the shadows all the time. So, and we'll eliminate a lot of that stuff too. But a lot of people, so the other thing too, you'll want to know is that a lot of these ticket cases, we're dismissing them across the county. And all these justice of the peace courts, all these issuance of a bad check cases, all these little warrants that you get pulled over and they arrest you and search your car and find this, that, and the other and take you down and then charge you with a felony. Well, guess what? We're getting rid of those. And we'll get rid of the warrants that go with them. And so we've already dismissed thousands of those. And I don't know how many tens of thousands we will dismiss, but we're in the process of going through that in every JP court in the county, plus all of our courts, and dismissing felonies that are, except for violent felonies, over 5 years old, misdemeanors over 5 years old, and then we're going to the JP courts and dismissing tens of thousands of cases there, and which is good for the JPs because their system is not digital. They've got files. And some of their places, if you go, I don't know if you've ever been to a JP court and looked in the back, it's just box after box. That's what that is. All those cases that nobody's paid any attention to for years. Everybody's afraid to go dismiss them. I'm like, go get rid of them. And so we're in the process of doing that. So we're trying to help some of that process. We can't keep them from writing you the ticket. You got to show up, and all of that stuff. But if it turns into a problem later on and it dangles around long enough, we're going to dismiss it and let everybody move on. So the JPs like it. They're happy. They get some space. They get to clean up their stuff. Yes, it's less likely that, somebody who had something 6 years ago can wind up in the county jail and this, that, and the other. So it's got some, some good effect to it.
All right, so one final question. Can we get you to commit to another State of Smart Justice event in the future?
Can I do what?
Can we get you to commit to another State of Smart
No,
Justice
I'm
event?
coming back. I'm done with you. Dominique Walker.
All right, so if anyone wants to get plugged into any of the ACLU Texas Smart Justice events that we have, you can come see me afterwards. You can come and speak with one of our panelists. My information is up here. If you're interested in any of one of the 7 pages of commitments that Cruzo committed to, you can go to dallasda.org. But join me in thanking John Cruzo for coming for today. And thank you all for coming.
Can I get a picture, sir?
This is William, hopefully your favorite videographer from Two Hats Publishing. I hope you enjoyed this video. If you like it, please leave comments below, or like, follow, or subscribe to us and get notices of all our videos. We love it, even when you call.